No one lays down the law like Car and Key. This is the Law Report on SAFM.
And a very good evening to you from tonight's Law Report program. Now, as you know, once a month here on the Law Report, we run a legal clinic trying to answer a range of questions on a number of different topics. And tonight, it's again time to open the lines for you to ask that particular question that doesn't quite fit into the other topics we discuss here on the Law Report. I'm joined once again this evening by attorneys Arinda Trutter and Andre Nokia, and they're attorneys at Skuman Law Inc., attorneys, conveyancers and notaries public. Arinda and Andre, welcome back to the show.
Thank you, Corinne.
Thank you, Corinne.
Quite becoming quite the duo, the two
yes.
of you. So, thank you. If you have any questions for us, you can call us now on 0892 10 2010, 0892 10 2010, or you can SMS us on 40938. Now, we just have a few emails to get through, just three, I think, not too many of them. So if you'd like to call in the meantime, leave your name and number with my producer, and we'll call you back as soon as we're done with those emails. Right, the first one is from a listener who says, my granny passed away in April without a will, leaving 6 children. Which one of them was living with her and me permanently, and the others are married? So in other words, some of them are living still with the mother. My question is, says the listener, is how to go about changing a deed and who is liable to register it in his or her name. So, I mean, basically that's the 6 children, 2 of them were living at home still, granny died, and now obviously there's no will, so I would imagine you can't just put it in one name now. That's the problem.
Yeah, Corinne, from how I understand this question, it's the granny that passed away, leaving only the 6 children and no surviving spouse. So if a person dies without leaving a will, the estate will devolve in terms of the Intestate Succession Act. So this means that the legislation provides exactly how the estate will be divided between the beneficiaries or the heirs. In this case, it seems that the grandmother, as we said, had 6 children. This means that all 6 children will inherit the estate in equal portions.
So the fact that 2 of them are still living there makes no difference at all?
It makes no difference. The fact is there's no will, 6 children, all will inherit equally, which means in terms of this act, this house will devolve upon all 6 children in equal portions. Irrespective whether the children were married or not, or whether they were living in the house or not. There is law that says that the child who lived in the house will be entitled to remain living in the house, and the executor of the estate will be appointed by the Master of the High Court, and they will appoint attorneys to handle the transfer of the estate, of the property. So unless there's an arrangement or agreement between the children, the property will then be transferred onto the names of all 6 children. And actually there can be agreements between them to transfer the house onto one of the children, and then the rest gets a portion of money or a payout from the other children in whose names the house is transferred.
So you can effectively buy the others out if you want to?
Correct, yes.
Okay, but the ones living in the house can't go and have it transferred into their name just because they were living there?
No.
But they do have the right to continue living there?
That's correct.
Okay.
Unless it's agreed by all 6 that the house will be sold to someone else.
Okay. Right. Okay, there was another question. I'm a little bit blind this evening because none of our printers are working. So I'm sort of trying to find out all these questions that we have on the computer screen, on the pieces of paper that Arinda and Andre have. I just don't have any paper tonight. Okay, the next question is, it says, I'm subscribed to a tracking company for my vehicles from 2013 to date. Around last year, 2016, I called the company to check my vehicle's connection with their system and was advised to do so regularly. I was told that they cannot see my vehicles in their system. Although I was surprised as to why they were not found, I never changed anything. I continued paying to date. Around March this year, one consultant from their tracing agent called me to say I have outstanding payments. I inquired as to why I was not told about it earlier. The agent said I was liable for this payment. I refused to accept this, as no written proof that there was a default in the payment for about 5 months, which I didn't know about. I never checked with my bank as I knew things to be normal with my payments for their service on the tracking of my vehicles. Now, who should take the blame on the payments, as my budget would never allow me this alleged unpaid subscription? No official written demand from the tracking company, but only a telephone demand. My worry is that were my vehicles not covered during that period of termination from them. Sounds a bit of a mess.
It does sound like a mess. So first off, it seems that this listener has paid for a service which this company has failed to offer. which could possibly be a breach of contract on their part. If this is in fact the case, then this listener is entitled to claim for its financial loss suffered as a result of the breach.
It doesn't sound like anything happened in the interim. It just sounds like for some reason they couldn't find his vehicles on their system, which in itself should have alerted him to maybe this wasn't the best company to be with, whoever they were.
Yes.
But I don't think he suffered any loss by all accounts, except for now they're trying to charge him again.
Or otherwise, for paying for a service for that few months that apparently the vehicle was not on their systems, which means that he's been paying, let's say it was 6 months, he paid for 6 months, and in those 6 months, if the vehicle was stolen in that 6 months, they wouldn't have been able to find it. So in effect, he suffered a financial loss for paying for something that he hasn't gotten, which is a breach of contract. Now, he hasn't mentioned anything like that, but he does mention that they are claiming money from him, although not formally as of yet. But there is a defense in law, which I'm going to use the Latin phrase. It's exceptio non addendum contractus. So this defense is raised against a contractual claim for specific performance. So if it may be used if the parties' obligations are reciprocal to one another, which means the one party pays for a service which the other party is then obliged to offer. This person paid for this service which wasn't offered by this person. This defense may be raised if they in the future come after him for the money.
But they are coming after him now for 5 months worth of premiums again. I mean, he's already paid for it once. They didn't give him the service, and now they want it again.
Yeah. So that's what this defense is about. If he wants to, now from what I understand from this email, they haven't instituted formal collection terms, but he can raise this defense, saying that I'm not paying that money because I tested it and my vehicle wasn't on your services.
Now, can he actually ask him to pay back for those months that he was paying that they didn't have him on the system?
You can.
So he can, okay.
In a case like breach of contract, a party can ask that he's put into the position that he was before the contract was entered into. That means that before they entered into this contract, he didn't give them any money and they didn't offer him any services. So for those X amount of months that he paid them but didn't get the service, he is allowed to claim a reimbursement for those installments that he made.
I'm sure he'll be delighted to hear that.
Yeah, it's a formal legal procedure in court action that will need to be instituted. But if he does have proof of the payments and the contract and so on.
By all accounts, it looks like it's coming off a bank account. So I'm assuming it's like a stop order or something, a debit order. So you would actually have it on your bank statement. If you can prove that he's been paying it all these months, he hasn't been getting the service, he can actually claim breach of contract.
Exactly. So if everything is as this listener says and can be proven as you said, then he will be entitled to claim for reimbursement of the X amount of months that he paid for the service.
Oh, I'm sure you'll be very pleased to hear that. Right, our last email is quite a sad one, and this is, as I said, our last one. So if you'd like to call us, it's 0892 10 2010, and the SMS line is 40938. Our last email says, my dad's eye was completely disfigured by a laser surgeon. We have the papers and medical certificates to prove it. We also took lots of pictures. What steps can we take? He died later. That is very sad. I'm very sorry to hear that.
Yes, it's very sad. First of all, our condolences to the listener losing his father. It's awful to hear, but it's happening more and more where people are taking their doctors or their surgeons to court for medical malpractice. But the listener should know that it's not an easy route. It's not an easy process to follow. It's going to be very costly and very drawn out. Because what you technically have to prove in a case like this, you have to prove that the doctor or the surgeon was negligent and that it caused harm and financial loss. So with negligence here, we speak about what we call the reasonable person test.
Before we go any further, Arinda, I just want to ask you, the fact that his father has now passed away, does that have any bearing on the case?
Yes,
Okay.
that will, because if you look at the financial loss that can obviously be the medical costs that they paid up to this date. But if the father was the sole breadwinner of the family, then that can also mean future income. So they can claim for that as well, and that will have an effect on that claim. But to prove this is going to be hard. There's going to go a lot of admin into it, a lot of evidence collecting, including every medical record known to that was there for the father.
He says they've got it all.
But he says they have it all. So hopefully they can prove their claim. But it's the court will also look at the type of surgery, what the normal risks are, and what the normal outcomes is overall. Everything like that will be taken into account when the standard of care is basically tested in court. So what I would say is the listener should approach an attorney that deals with medical malpractice.
Because that is a specialized field.
Quite a specialized field. So find someone that specializes in that. They'll send a letter of demand firstly to the surgeon, and if there's no response, then they can issue a summons and claim damages for their loss. But as I said, it can take up to 4 years for a matter like this
really?
to get in front of a judge. So it's not an easy route, and it's going to be very costly. But the opposite side of that, they can report the matter to the Health Council. But from what I've read and from what I've heard, that's not a very effective route to take. So the court route would be the best here, but it's not something to just jump into.
You've got to understand it's going to cost you.
Cost
the sad thing is it could end up costing you more than you'd actually get paid out.
Exactly.
Which I don't think is right, that you've got to think about those sort of things, and then you kind of, we're not going to worry about doing it because it's,
it's such a sad story.
It doesn't sound right to me. But there is the opportunity to do that, and that's where you just need to go and speak to a medical malpractice attorney.
Yes.
I'm not entirely sure, but I think there are attorneys specializing in this field, and also other third-party claims that do these sort of matters on contingency basis. So this listener can phone around, get some information. There should be attorneys out there that can help him.
So basically just to explain, contingency means that if the attorney takes your case and you don't win the case, they get nothing.
They get nothing, but if they win, then they get a percentage, 30 or 40% of whatever money is in the success judgment.
Okay.
These attorneys they'll do a consult, they'll look at all the papers, and they'll look at the strength of the case before they take it on. So they don't take on cases if they don't know there's a strong chance of success.
Okay, so the listener does have some options.
That sounds like the best option to take then, especially if they have all the evidence that they say they have.
We're listening to the Law Report. It's our law clinic tonight, and joining me in the studio is Arinda Trutter and Andre Nokia. So any questions you might have on whatever topic you'd like, except for labour law and property law, anything else, you're very welcome to call us. So give us a call now, 0892 10 20 10, or SMS us on 40938.
The Man Cave, created for men by men, returns Tuesdays at 9 p.m. SABC 3.
You'd be surprised by the difference 67 minutes of your time can make in your community, your country.
Dalipunga, Tela Bufa, Matiba, Molomsila, Vela Bambensele,
SAFM, the power to make a difference is in all of us. No one lays down the law like Car and Key. This is the Law Report on SAFM.
Well, our first question we had this evening related to a will, of which there wasn't one, sadly. We've got Wills Week coming up in September, is it? And we're waiting for the list of attorneys to be released.
Yes.
And just to let the listeners know, if you're interested in finding out where the closest attorneys to you are that are participating in National Wills Week, just drop me a mail to law@safm.co.za. And once that list comes out, and let me know which part of the world you live in, which suburb in whichever province, and then as soon as that list comes out, I'm actually keeping a file at the moment of people who are wanting to be informed of when that's coming out. So drop me a mail if you'd also like to go off and get your will done free of charge. It's a basic will. So if you've got sort of 10 houses and 6 whatever else, it's a basic will for people who have got no will. And as we saw now with our first question, with a granny died and there's 6 children, 2 living in the house, and there's no will. So if granny had possibly wanted the 2 that were living at home to inherit the house.
Exactly.
No, they don't.
It would have made the whole process faster as well.
Yes.
Absolutely, because without a will, how long does an intestate estate sit in the master's office? That could take probably longer.
It can take a long time, especially even with a will. It takes a while. So without a will, it can even take longer than that. It can take anything up to 6 months to a year.
Wow, okay. So
That's
take advantage of National Wills Week. It happens every year. And drop me a mail to law@safm.co.za and I will send you a list of participating attorneys in your area when that list comes out. Just a reminder again, the phone number to call 0892 10 2010 or SMS us on 40938. Just one quick thing on the will. Somebody's just SMS to say, if you make your own will, who must sign each page?
Well, there's certain formalities that need to be taken into account when signing a will. A person can do their own will because a will is that person's last will and testament. So it needs just the formalities of signing the will. Only the person that makes the will needs to sign, together with 2 witnesses.
Because I was reading something the other day about the person who signs the will has to sign the bottom of every page as well as the witnesses. Is that correct?
Correct. So every page at the bottom needs to be signed by both the testator or testatrix as well as both witnesses. So no initials, full signatures on every page.
Okay, I thought it was just your initials.
No, full signatures.
Oh, okay.
Yeah.
And then you all sign at the back page where you're doing in front of the witnesses. So don't you go off and sign it and then
Yes.
2 days later go and say, sorry, could you just witness my signature, which I signed 2 days? That's not witnessing anything.
Yeah.
All done in the presence of each other.
And it should also be as close to the writing on the will as possible, your signature. So there shouldn't be blank gaps in your will at the bottom.
I'm
So
going
it's
home to
just-
check mine. I'm sure I've got blank gaps in mine somewhere. You're making me nervous now.
Yeah, there's case law that one page of the will was 2 or 3 lines at the top of the page, and the will was signed at the bottom of the page, and that page of the will was declared void.
Okay, I'm going to go and measure the gap now. I'm sure it's close enough.
So as close as possible.
Okay.
Oh, and it's also important that your witnesses are over the age of 16.
Oh, yes, that's the other
Over
thing.
the age of 16, and there's many more formalities.
Well, there can't be someone who inherits in the will
Yes.
can't witness it either.
They can't inherit, they can't be the trustees or the executors and so on.
It's
Which
not
means they can't be the
advi-
executors. So yeah, no, I'm just giving an example. So basically, if just as an example, so if it's my will and my husband is the executor, just
Yeah.
say he can't be the witness.
Exactly. So if
Well,
you
that's my will's fine then. Okay.
if you nominate your husband to be the executor, then he can't witness it. Yeah.
Okay, and they can't inherit either. Okay, it can't be someone who.
Obviously advisable not to do your own will.
Yeah, well,
Rather
absolutely,
seek
yeah.
a professional to
I've
help
heard
you.
too many horror stories to try and do that. So yes, right. Okay, let's take some calls. Our first call is from Nick in Nelspruit. Nick, good evening.
Good evening, Carter and team.
Hi, how can we help you? Yes,
The last
Nick.
time I phoned was to Nigel Murphy on microphone in a long time
Good
ago.
grief! I used to work on that show, Nick. I mean, that's giving my age away now.
Ma'am, I wonder if you can help me. It's in connection with early termination of clause and whether we are protected by the CEA for a commercial lease. We actually basically had a 5-year lease which we fulfilled. It was extended for 3 years. We were running into difficulties. We're a small business. We were running into difficulties and we gave 6 months notice and paid for the 6 months. Now that the landlord wants an extra 2 months and we're sitting in court right now. I want to know are we protected by the CPA in terms of a 20-day notice period? Because we've given 6 months notice and the landlord wants another 2 months as an exit, arrangement.
Generally, the Consumer Protection Act does not apply to businesses unless the business is as an annual turnover of a fixed amount, which I think is currently 2 million rand. You can just correct me if I'm wrong. So, if the business's annual turnover is less than 2 million rand, you might be protected in terms of, I think, Section 14 is the fixed term contract section in the Consumer Protection Act. Which stipulates the 20 days cancellation. Now,
yes, our business is definitely less than 2 million, yes.
Yes. Now, the Consumer Protection Act isn't very clear because it does provide that the landlord is entitled to claim for the reasonable damages if a replacement tenant can't be found. Now,
Yes.
nowhere in any case law or any part of that legislation is the specific term after the cancellation specified, and neither is the amount which is referred to as reasonable damages. So it's unfortunately at this stage a very grey area of the law, and if it is in court already, it will be a matter for argument regarding the
Yes.
costs and the actual amount that can be claimed in terms of the damages.
Can I just ask you something? Because Nick was saying he was originally given they gave 6 months notice, which was fine, and now suddenly the landlord wants an extra 2 months.
Yes,
Can you do that?
That does definitely not sound reasonable to me. I think 6 months notice is more than sufficient for the landlord to find replacement tenant. It's up to the landlord to find a replacement tenant, not up to the tenant.
Yeah.
And the landlord can't, you can't. What it seems to be in this case is that the landlord, sat back and didn't do anything for that 6 months, and now the time comes where you need to move out, and he wants another 2 months to find someone else, which in my opinion doesn't sound reasonable.
Yeah, just to set the record straight, Karen.
Yes.
It's now 18 months later, and they have not found a tenant, and that's what they responded in the affidavit to us. So, that is totally unreasonable. That's the first point. The last point is that in terms of the lease agreement, there is no termination clause. Does the lease agreement not have to have a termination clause?
There's usually a termination clause, but very few of them actually specify in detail for early termination. And if it doesn't specify for early termination, then you have to go on the Consumer Protection Act. And again, unfortunately, this act doesn't apply to companies with an annual turnover of more than.
Well, he said he's under the 2 million, so
Yeah,
he would actually fall under that.
So he would fall under that, and the best would be to ask for proof from this landlord that he has actually tried to find replacement tenants. You mentioned he does have an affidavit stating that they couldn't find someone else, but you're entitled to ask for proof that he has placed advertisements wherever.
But the point is, it's not Nick's fault that the guy can't find a tenant. He can't carry on being a tenant until the year 20 dot because the landlord can't find a tenant. He's basically, the way this is going sounds to me like he could be stuck there forever. There must be a cut-off point at some point.
Just as a matter of interest, we were only about 3 months away from the completion of the 3-year period anyway. So basically, we gave the 6 months notice, and we were like 3 months away from the normal 3-year lapsing anyway, and after which we would have come out clean, with no issues. So the landlord has only lost, in terms of opportunity cost, 3 months of rental opportunity. After that, he has failed to find a tenant for the last 18 months.
And that's really, for 18 months, he's just sitting there. Oh, no, okay. Yeah. Doesn't sound right,
Okay,
Nick,
thanks
at
very
all.
much. So at least I have some information to say that we are our turnover is less than 2 million, and the CPA hopefully will protect us. But as we also heard from your guests, is that it's a very grey area. I've got 2 articles that I've read from the law reporter somewhere, which I've got there, which talks about early termination. But it's something that I'm sure that more work needs to be done.
Definitely, the legislation needs to be clarified, and with time, case law as well will, it will give people a platform and platform to determine the specifics of this legislation.
It's that reasonable thing. They haven't said what is reasonable. That's where the problem comes in.
Exactly, yes.
Because reasonable to one person is unreasonable to another.
Well, the landlord, I'm sure, thinks 18 months is pretty reasonable.
And it's-
Nick's not happy about that, so he doesn't think so. So it's difficult. Nick, well, I wish you luck with that, Nick.
Karen, thank you to you and your team. You're doing a good job.
Thank you.
And thanks once again for taking my call. You did say at the beginning, no property matters, but you took my call, and I'll thank you very much for making that allowance.
Only a pleasure. Thanks, Nick. Good night.
You've done good deeds for the week and for the year. Thank you.
Thanks a lot. Bye-bye.
Bye.
Bye. Right, off to Jerviston now. John, good evening.
Good day, sir. How are you?
Very well, and you?
Fine, thank you, sir. I just wanted to get clarity. I actually had a civil case against the police for an assault that I had broken ribs due to that assault. And I just wanted to find out, my case was in 2008. It dragged for 3 years till 2011. And it was thrown out of court. Then I was told there was no claim because I was only locked. In actual fact, an assault on that morning happened that I was put in the cell till the next morning. Then the next morning, I went to the nearest hospital because I was in pain. Only they picked up that I had fractured ribs, and I've got a medical report that I got a lawyer who represented me in MLO. Then the case dragged for 3 years till 2011. I was actually working for ESCOM that time, and I was traveling from Hendrina to Middleburg, as I was followed by the police, and then they were charging me for negligence and reckless driving. As they say, they followed me and they couldn't catch me the speed that I was driving. And the next thing, they stopped me because they called other police, because there was a roadblock in Middleburg where I was stopped, and those policemen pointed firearms and they searched me and they kicked me in such an extent that I had fractured ribs. Then they locked me up that morning till the following day. Then they released me. I went to the private clinic in MLO, where I was checked and they discovered that I had fractured ribs. Then I went back to the police station to open a case for unlawful arrest and assault by the police. Then the case dragged for 3 years. Then it was thrown out of court. Then I was told I was only locked up for a few hours. There was no case that I was assaulted, though there was proof of x-rays and record that I was assaulted.
Sorry, John, this is a very long story. Sorry, we've got lots of calls holding on here. Would this be something that maybe he could take to IPID?
Yeah, well, I actually wanted to make it brief. Then what I did, I went back to that lawyer. I requested for that full file so that I can refer that case to another lawyer. The other lawyer took it and he said it was Afrikaans. He couldn't transfer it. He needed a translator. And then he kept that file with him till now. Then he couldn't release the file and give it back because he requested for some money that I must give him, I think about 1,200. Then he said to me he can't release that file to me. I needed to give him 1,000 rand. I just wanted to find out on that case, what is the closure on that case? What advice would you give me on this case? Because I've got a full file and medical report and x-rays for the assault.
Okay.
John, I'm going to try and keep my answer brief. This isn't my area of speciality, but from what it seems, there might be a case, depending on the facts, for a civil claim for personal injuries of sorts, and then also the unlawful arrest. If that can all be proven, this case shouldn't have been thrown out. But you remember, this isn't a criminal case necessarily, which means that the state isn't going to press prosecution, which means it's up to you to make this case against the South African police services. And
that's what I did initially.
Yes, which
it was thrown out with the proof of x-rays and medical report from the doctors that I suffered fractured ribs and all that terrible incident.
Okay, can I just ask you, can you take the case back to court if it's been thrown out once before?
It depends on what he means by thrown out. If there was a judgment and the judgment was dismissed or not granted, then he can't take the case again. However, if this case is a fact that it just hasn't come before the court in a trial situation, then you can still just take this to court. You can find an attorney to assist him, because he has instituted action already, which seems in 2008, which means a prescription would have stopped at the time when the summons was issued for the claim. And at that stage, it's up to you to find an attorney who will be able to represent you. I recall you mentioning something about fees, which is probably a personal matter between yourself and that attorney. However, an attorney is allowed to take fees for the work that has been done, and if attorneys aren't being paid, then they are allowed to keep documents until the fees are settled. So it's best to find out with them what exactly is going on, get that in writing, and then you'll know exactly why the case was thrown out, if thrown out at all, or if it just hasn't proceeded yet.
Okay, John.
Should
Good luck.
Who do I write to? Can you just be specific? Because I'm going to pay that guy and get my file back with all the medical records.
Yes, you'll need to write to your previous attorney, and then you'll need to find another attorney who specializes in these sorts of matters, who will be able to assist you in personal injury, unlawful arrests, and so on.
And we can't, unfortunately, give names of attorneys on the show. So
No. I'm not going to give you the details, but I said it was 2008.
okay, John, I think just get hold of the attorney you were dealing with to get all your records back, and then possibly find yourself an attorney that specializes in this particular kind of case, and that would probably be better. All right, good luck to you, John. It sounds like you went through a terrible time, but good luck to you for the future. And thank you very much indeed for calling.
Is it still valid that I can continue with it? That's my question.
We can't answer that unless we've seen all documents. So it's an impossible answer to a question to answer without having seen the facts of the matter. So, for example, if there was judgment, then we can tell you that you can't proceed. Or
John, you said it was thrown out of court. What happened when you went to court with this case?
The court didn't reflect that I was assaulted.
Yes, but when was there actually a court case, and they said, what did they say? Other than not reflecting that, what did they say?
They said they just locked me for a few hours.
No, but I want to know what the judge said, John. What did the judge say when you went to court?
Okay, because I don't have the documentation.
No, we're just trying to figure out whether or not the case actually went to like a trial situation, or whether before the case even got that far, the judge says we're not taking the case.
Okay, can I call this number again, or which number can you refer me when I give this final judgment for this?
This number is only just used on a Monday evening for the law report. So
it's best to obtain all the documents, all the details from this case. You get that case number, the court in which it was. Then you go see an attorney, and they'll be able to assist you specifically with what exactly is going on and what has happened and what your options are going forward.
Okay, I cannot refer it to the South African Law Society. I cannot take it to that level.
The South African Law Society, you can approach them if you need a pro bono attorney. Then you can either approach the Law Society or legal aid.
Can you give me the number? I'll listen over.
We don't have it. We don't have it in the studio with us, John. I'm so sorry. If you can actually look up on the internet, if you can, just look up Law Society of South Africa. You'll find the one closest to you.
Thank you so
much. All right.
For your advice.
Thank you, John. Thank you. Good night to you. Bye-bye. You're listening to the Law Report. It's our law clinic this evening, and my guests are attorneys Arinda Trutter and Andre Nokia. So join us if you'd like. We've literally got about 20 minutes left now. If you'd like to call through 0892 10 20 10 or SMS on 40938.
Passion is born out of the desire to take any fight right down to the wire. The PSL Awards are here. The South African football curtain closes with the Premier Soccer League Awards on 10 July 2017 at 9 p.m. Be part of this momentous occasion in honor of our football heroes. Live on SABC1 and update on your favorite SABC radio station. Proudly brought to you by SABC Sport, for the love of the game.
Ooh, baby, tonight is our night.
I'm sorry, I can't.
Huh?
You know, baby, I'm stressed about work and exams. If I fail, I won't get the promotion, which means I can't buy your dream house. So I want to have a quiet night, alone.
What?
No more excuses. SMS help to 32110 or WhatsApp to 072 315 2574. Men's Clinic International, specializing in male sexual health.
No one lays down the law like Car and Key. This is the Law Report on SAFM.
Right, back to the questions, and we've got a few SMSs I just want to get through here, or if I can get this thing to work. It says, my name is Sibusiso. I would like to know how long it takes for the state to disclose assets or monies of a deceased because my father died in 2014 in July of that year. He was 67 years of age without having a will. He was working for an engineering firm that made it difficult for Mom to get all his belongings and only paid out 70,000 Rand. Up to this day, nothing has surfaced from the Provident Fund or the UIF. How can I help my mother to win this drama?
Yeah, that should not take that long. Normally, in the process of the estate being wound up with the master, you just have to send a copy of the death notice to the UIF or to the Provident Fund that needs to pay out, and they note it on their side, and that's the end of it. It shouldn't take...
It's 3 years now.
It shouldn't take years. It should at least maximum take 3 months.
So what, he should actually contact them now and
He
say...
should contact them and make sure they have a copy of the death notice so that they can see this is what happened, and it should pay out.
Should, being the operative word, yes. Should.
There's no way around it. They should pay out.
Okay,
Unless there's something that we don't know about.
Yeah,
but
another SMS says, my mother's husband died, leaving a will. The husband had no children, and in his will he left the house which he owned with his previously deceased wife and all the other items to the nephew of his deceased wife. In the will he didn't mention anything about my mother and that they were married. This was a civil marriage. I need advice on what my mother should do. What are her rights? Note, we can't afford a lawyer. So obviously the husband had been married before.
Mm-hmm.
When he died, his will actually left everything. He obviously hadn't updated his will because he'd left everything to the nephew of his previously deceased wife.
Yes.
So the current wife that he was married to when he died has now got nothing. And so this is because you need to update your will like
twice
all the time.
Yeah.
That's
sorry.
Oh,
but what do they do now?
So obviously, unless they are married, they were currently married in community of property, where she would have automatically 50% of everything. Unless that's the case, if they were married out of community of property, there's nothing she can do.
If he goes to court, because a will needs to be disputed in court, that's the only way. If they should be successful with proving that this will, that the last one that was left wasn't the actual last wishes of the deceased, then the deceased will have died intestate, which means without a will.
Isn't there something about supporting, if just for example they were elderly, just say, and the wife now was obviously depending on the husband to support her. Now the husband dies, she's left nothing. Is there not some sort of right to support somewhere along the way?
Yes, she would definitely have a right to maintenance from the estate. That's certain, because she was married to him, so she would have the right to claim maintenance to the standard that she was living before he passed away. Unless obviously she was the breadwinner, then there's no real claim for maintenance. But if she can prove that she has a claim for maintenance, she can claim that. But unless they can dispute that will, then
they do have a possible option here. But the first thing to look at is whether they're married in community of property.
Yes, because
which means she gets 50%. The nephew that's inheriting would get his 50%.
The rest of the 50%.
But she would still get something.
Yes.
If that wasn't the case, she's still entitled to maintenance.
She can claim maintenance from the estate.
So there are a few options that they can explore.
Very tough.
Yeah, it's one of the things. Nicolene, I know, always goes on and on about doing your will. So
she
yes,
would have hated this question.
No, she wouldn't have liked that question. There's another one. If my husband signed a deed of sale on our house without me citing the sale, we are married in community of property. Is that sale valid? No witnesses signed. No. It's deed of sale on our house. So it's obviously the husband selling the house out from under her.
Yeah, when married in community of property, there's a joint estate, which means both parties will have to, the property is automatically registered in both of their names. So both parties will have to sign. If both parties don't sign, the other party can give written consent. But because the house is owned by both of them, the house can't be sold without the other one's consent.
And if it was they tried to do that, the sale is null and void.
They won't be able to sell the house. At least I'm not sure. We'll ask Arinda to confirm whether it's possible that he sells his 50% portion of the house.
Well, so she can have some strange person living in the house with her then. I mean, that's just weird.
No, that shouldn't. If they're married in community of property, the house is jointly owned. So his 50% is her 50% and her 50% is his 50%.
Okay.
So unless she gives that written consent that's lodged at the deeds office, it won't go through.
Right, we seem to have some more calls on wills. Don in Mitchell's Plain, good evening.
Hi.
Hi, Don, how can we help you?
I've got two questions.
Okay.
My grandmother passed away about 2 years ago. I am the executor of the will.
Okay.
What I wanted to know is, I don't know, I've got some advice to say, look here, I have some time to register the house on my name, because the house is worth more than 200 something thousand rand. I have to get a conveyancer, and the conveyancer is asking like something like 4% of the property,
So-
of the worth of the property. I just want to know how long do I actually have to transfer the house on my name?
Okay, so basically you're saying your grandmother passed away, you're the executor of the estate.
Yeah.
Who inherited from your grandmother?
Yes.
You did.
Me, yeah.
Okay, so she died. Are you the only heir to the estate? Is anyone else inheriting anything?
No, nobody.
It's only you. And now you're waiting to have the house transferred into your name. And you
I
said...
went to register it when she passed away. And people said to me, I don't have to be like urgent about it, because I am the executor. So I don't know, do I have a certain time limit?
Okay. You want to know, is there a certain time... When did your grandmother pass away, Don?
About 2 years ago.
2 years ago, okay. So he hasn't yet transferred the house into his name, and he's concerned because he said the house, I think he said, was valued at around 200,000, and the attorney doing the transfer is asking for 4% as the cost. He's just trying to figure out if all this is what is the house supposed to be.
Yes, so the house needs to be transferred into his name by an estate transfer.
Is there a limit in time, though? That's the other question.
No, there isn't a limiting time, but the problem is, as long as the house is not transferred, the estate is not wound up with the master, so the estate is still lying open, and he is not released as an executor of the estate. And in the meantime, there's obviously rates and taxes on the property, and the estate is keeping on paying that, which is not great. But it's an estate transfer, so it's not the formal transfer of a sale like you do with a normal property, but the conveyancer still gets to charge their fee. Depending on which conveyancer it is, they have different fees. Everyone works on different fee structures, so I can't comment on the 4%, but they are allowed to obviously charge their fee. There is, however, an application that you can bring to the deeds office if you don't have the money to pay for the house to be transferred into your name. You can go to the deeds office, find out at the counter what that application is, get a form to fill in, and you apply to the deeds office and say, here's the reason for the transfer, I don't have the money, can you please transfer the house into my name? And the deeds office will do an endorsement on the title deed.
So in other words, what happens then is once you ever sell that house, that's the first thing that gets paid from the sale.
Yes.
Okay. Don, does that help you at all?
Yeah, thank you, because I just wanted to know that I've been getting so much information from people that I wasn't sure what you're supposed to do, you know?
Okay, so basically, just to put it in a nutshell for you, there's no time limit on the transfer, but it is advisable to do it as soon as possible. If you can't afford to pay for the transfer costs, you can apply at the deeds office, and they will put an endorsement on that actual transfer on the title deed to say that you're the owner of the house. And then one day when that house is sold, that is when from the sale price of the house, the money for the transfer will then be paid from that. So you do have that option.
The deeds office, is that with the municipality?
Sorry?
The deeds office, is that the municipality?
Municipality? No, it's not the municipality.
It's not the municipality, it's a separate government office. You can just Google the deeds office in your area. Cape Town has a deeds office, and most of the capital cities have a deeds office. So just Google the one in which area the
he's
property.
in Mitchell's Plain, so he'll be in Cape Town.
It will be City of Cape Town. So yeah, in Cape Town, in Plain Street is the deeds office.
Okay, thank you very much.
Thank you, Don. Good luck with that.
Okay,
thanks. Bye-bye now. Good night. Right, and next call is up in Umtata, also with Wills Week. Mngoma, good evening.
Good evening, ladies.
Hi, how can we help you, Mngoma?
I just want to find out about the Wills Week.
Yes.
I'm in Tata. When will that be? What will be the?
Okay, Magoma, we don't have the we don't have the list of participating attorneys yet. But if I'm going to put you back to, no, we've actually got I've got your cell phone number. If I'm going to put you back to my, no, he's actually on the phone right now. We've got your cell phone number. I will send you a message, and then you can just tell me, you give me your email address. Don't give it to me over the air. And I will then, once we get that list, I will then send you a list of participating attorneys in Umtata.
All right.
Okay, because they're not up just yet. But as soon as they come up, I will send you the list.
Thanks, lady.
Thanks, Magoma. Thanks. Bye-bye. Yeah, I think this Wills Week thing we've had so many questions tonight, sad stories of people that there haven't been wills. And, you know, I talk to my friends who look at me as if I'm insane because I keep doing mine. It keeps getting redone all the time. But every time your situation changes, your will should change. And especially if they're children.
Yes.
As they grow up, you know, because when they're little, you've got guardians. And that's the other thing. You know, I like to talk about, you need to actually put it in your will. If heaven forbid something happens to you, who's going to look after your children? You don't want there to be this almighty bun fight between all the members of the family about who's going to bring up the kids. You need to decide, put that in the will. And as they grow up, those basic things need to change.
No, agreed.
It's fantastic that the awareness is also on the rise. People phoning in shows that they are starting to think what will happen when myself or my spouse or someone dies, which
I think they just get sick of me going on and on about it. You know, it's like Nicolene and I have this pet thing about wills. You know, like you have to have one.
It's a great sign, yeah.
Yeah, but I mean, as I said, the Wills Week is for basic wills, and it's really just. I mean, you might not think you have very much, but everybody's got something.
Yeah.
You know, that you might like, even if it's your favorite vase or your favorite whatever. You know, your kids or whoever could end up having a bun fight over it once. You know, you go.
Yeah, even if it's just your salary in your bank account.
Yeah, or your provident fund or your something. Yes. You know, there could just be something.
The majority of people will have a basic will, even if you just say, everything I have go to my spouse, and if she dies, then to my children or something like that.
Yeah, I mean, that's what I'm saying. Even if it's that basic, but we all need to have one. So please, 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 Wills Week's coming up. Take the opportunity. It's completely free of charge. Don't pay a cent. Go and have it done. Right, let's pick up another call in Johannesburg. Arnold, good evening.
Good evening.
Hello, how can we help you, Arnold?
Around 2011, I was dismissed unfairly, and I took the matter through. I appointed an attorney, and arbitrator ruled that he didn't have jurisdiction over the matter. It had to go to court. This attorney since then has disappeared. He hasn't done anything. He hasn't filed anything at court. And I've tried contacting him, but his number kept on changing, and eventually I couldn't get hold of him at all for the past just over 2 years.
And where's your case? Must have you know, the time has pretty much run up by now. So, but you've got a valid reason as to why. I mean,
no, he did get a case number at the Labour Court, but he never filed the whatever documents needed to be filed. Is it an affidavit or something of that sort? I'm not quite familiar with it.
So what's happened to your case so far? You now obviously need to get somebody else to file that.
When I had gone there to the Labour Court, they told me that he's got to give them information, and then only they'll proceed with the case. The case hasn't been set down because they're waiting on the attorney. But he told me a different story, that he was waiting for the respondent to send him stuff. But time has dragged on. It's been happening since 2011. Now it's 2017. It's already 6 years, and I don't know if I have any grounds to. I actually don't know what to do about it.
Oh gosh, Arnold, but would his case not have prescribed by now?
That depends. If the claim was instituted, however. 6 years is a very long time. It shouldn't go on like this. I think this person should definitely, look at approaching the Law Society if possible. There seems to be some sort of negligence on his representative's part. So I'm not sure if that's something that might have happened, which is an option for him.
Have you done that, Arnold?
No, I haven't done that. If I do that, will I not need any documents because this attorney has the bundle with him?
And you can't locate this person?
No, at one stage I heard that he lost his fidelity certificate. And then,
and
then apparently he got it back. And then there was rumors that he's gone to work for a municipality in KZN. And since then, I couldn't get hold of him. And he had an office in Braamfontein, but he kept on not coming to the office. Every time I went there, they said they hadn't seen him. And then eventually they locked up the office for non-payment. But apparently he came and he retrieved all the documents that was in it, and he paid them whatever was owed, and he left. But since then, I just couldn't get hold of him.
Law Society?
Law Society, you say the matter was at some stage in
arbitration.
In arbitration in the CCMA, I suppose. I'm not sure if you can take that case number and see what documents they have and try and just get copies of the information from them, so that you at least have copies and of the evidence.
Okay, and then one other thing. He also accused the company of unfair labor practice, and after we had gone for the unfair labor practice, when it was said.
Sorry, Arnold, we lost you there?
Similar, but it was non-compliance of the road freight agreement. In that instance where he made a erroneous decision there to proceed with an unfair labor practice, am I supposed to be paying him for that particular thing as well?
Goodness, the best would be to probably just get the information and documents and approach Law Society.
Yeah.
I think
you need some further help with this.
Yeah.
So, get hold of the Law Society of the Northern Provinces, which is where you're up in Johannesburg, and just speak to them and take as much information as you can about this attorney, and hopefully they can help you with that. Arnold, it sounds like a horrible mess, but I wish you luck with trying to sort it out.
Okay.
Thanks so much. Thanks. Good night. Bye-bye. We've got a very quick, trying to get through some SMSs very quickly. The one says, I'm married in community of property. Can I leave my half to my daughter?
Yes, you can leave your half to your daughter, and the other half the spouse automatically gets.
Yeah, so your half doesn't have to go to the spouse.
No.
You can leave it to your daughter.
Yes.
Okay, right, that was quick. Right, next one. Good evening. If I marry someone with a child and I die without having a will, what are the rights of that child? Also, what rights and responsibilities does the biological father have? Potential stepdad. Well, this was from the potential stepdad. Wants to know.
So that would depend on the fact if he is adopting the child or not, because obviously if he adopts the child, then it becomes his legal responsibility, and the child will have a claim against the will if the child is in the will. If he dies intestate, then according to the rules of the act, but otherwise he doesn't have to leave anything to the child.
No, he's obviously wanting to look after the child,
yes,
because he wants to marry somebody who has a child, and he's worrying that if he dies, what happens to the child? You know, what are the... he's sort of saying, you know, I'm marrying this woman, she dies or something, and now there's I'm the stepfather, here's the child. Do I have any rights to look after the child, or does she automatically then go back to the biological father?
The biological father has
the rights, yeah.
Unless there's an adoption.
Yeah.
And then you obviously have to get permission from the biological father. You can't just go around adopting people. So
either that or a court order showing he's unfit to be a father. Yeah.
Okay, so but I mean, basically, you can leave whatever you like to in the will.
Wherever you want, yes.
Yes, absolutely. It's a little bit difficult. And it wants to know the rights of the child. That's always the court always looks at the best interests of the child. So,
always.
You know, I would think if possibly the biological father hadn't seen the child since the day it was born.
Yes, you can obviously bring an application to get rights, but it's going to have to go through court, and it's going to have to be argued.
It's not going to be easy. Right. Well, my thanks once again this evening to Arinda Tritter and Andre Nokia. They've been my guests this evening, and they're from Skuman Law Inc., attorneys, conveyancers and notaries, public practicing here in Cape Town. And Nicoline Skuman Law will be back with us for another law clinic on Monday the 14th of, gosh, can you believe it, August. Arinda and Andre, thank you very much indeed for your time this evening.
Thanks so much, Corinne.
Where was Nicoline this evening with all those will questions? She loves those. In next week's program, we'll be talking about UIF, and my guest next week is Teboho Maruping, is UIF Commissioner in the Department of Labour. That's the law report next Monday the 17th of July. We've had so many questions about UIF, we thought we'd go right to the source. So join us for that if you have any questions about that next week. And I'll be chatting with you again tomorrow evening just after 9, and it's Health Matters time. It's our monthly phone-in, and this month we'll be chatting about mental health with my guest, psychologist Daniel Rabinowitz. Stephen Kirk is up now with some nighttime music. Hello, Stephen.
Good evening, Karen. Catch you again tomorrow. Where there's a will, there's a way. I seem to remember hearing that somewhere. Good question. I did my will, I don't know, 25 years ago. Maybe you're right. It's time for an update. Thanks.